Greetings from Warsaw. For this program I have invited Zuzanna Śladowska, a fifth-year law student, head of the Corporate Law Study Society at the Faculty of Law and Administration of the University of Warsaw. Zuzanna is a legal intern in the real estate practice at Wardyński Partners.
Together, we'll tell you about the revolution that is coming in, how Polish firms will communicate with state, local administration and the courts. It will involve the launch of e-delivery, an electronic system to be used by public administration authorities, including tax offices and courts, to communicate with companies and citizens. The system will also be made available for communications between private entities, for example, between entrepreneurs.
Of key significance here is the legal effect of the service and acceptance of a letter via e-delivery.
Electronic delivery will have the same legal force as service by registered letter delivered with the proof of receipt. Therefore, it will be used in administrative proceedings and litigation. It will also be available to firms to communicate between themselves while performing their contracts.
We know that the government's main objective for e-delivery is to do away with traditional paper correspondence between authorities and companies, as delivered by postal workers. The intention is to reduce costs, to simplify and speed up communications. But what benefits will companies have from this system?
The e-delivery system reliably identifies senders and the recipients. Almost unchallengeable evidence may be retrieved from an e-delivery account of correspondence having been sent and delivered.
Finally, there will be no longer any doubt about who sent what to whom, when it was sent and when received.
The scanning of official letters will end, as they will no longer be in paper form. The electronic distribution of documents will make it easier to handle and archive them. The e-delivery account will be accessible via computer, smartphone or tablet, 24 hours a day, from anywhere in the world. With the help of search engine, a sender will quickly find a reliable e-delivery address for a recipient. Therefore, there will be no doubt as to which address to use for the recipient to send. For example, a notice to terminate a lease agreement, a payment demand, or a shareholder's declaration of exercising their preemptive right to acquire shares.
Please note, from now on, e-delivery may be written into contracts as one of the methods or the sole method of serving all notices and statements. This is because it gives certainty that if one party to a contract delivers a letter to the account in which the other contractual party receives its tax correspondence, that letter will be delivered to an address that is current, certain and administrated by persons authorized to receive correspondence for the other party. E-delivery will also be used to communicate with the company when shareholders exercise their rights. Let us now clarify who will have to implement e-delivery and by when.
All Polish public administration authorities of the state will have to implement e-delivery because they will be required to use it to send and receive documents. Companies will have to set up their own e-delivery accounts by 10th March 2024 at the latest.
Public trust professionals such as attorneys at law, tax advisors and notaries will have to establish such accounts earlier, by 30th December 2023.
From 2029 onwards, the requirement to use e-delivery will extend also to courts, bailiffs, prosecutors, law enforcement agencies, IG, the police and local government. Foreign companies that operate in Poland will not be required to set up e-delivery accounts, but will be able to do so after first obtaining a Polish tax identification number, NIP.
What will companies have to do to implement e-delivery?
By 10th March 2024, all companies in Poland must set up an electronic service account on a special online platform, obtain an address for electronic service, and then notify this address to the database of electronic addresses, namely a public register held by the Minister of Digitalization. The account will enable messages to be sent, received and stored, as well as provide access to a search engine for addresses of entities held in the database.
The electronic address for service issued to each entity consists of a sequence of letters and numbers. It is therefore not an email address.
The submission of an address to the database held by the Minister of Digitalization is tantamount to the company's consent for correspondence from administrative authorities to be served only in electronic form. From the time when the address has been notified, the firm will cease to receive from authorities' paper letters. A company must appoint at least one administrator for e-delivery account, therefore a person who will have access to it.
For example, in a real estate company that derives its revenues from renting office, warehouse or retail space, we would recommend appointing the following as administrators. A property manager to look after correspondence from leases and local administration authorities, the chief accountant to correspond with the tax office, an attorney at law to look out for any correspondence on litigation and administrative proceedings, and at least one member of the management board to oversee all of this.
Administrators will receive notifications to their email addresses when correspondence has been delivered to the account. The deadline for responding to a letter will run from the date when the letter was received in e-delivery account.
And who will pay for the operation of the account and the sending documents by e-delivery?
The account will be free, and the firm will not pay anything for its correspondence to or from any authority. It is the authorities, actually taxpayers, that will cover the costs of corresponding with firms.
They will pay fees to Polish Post, which will constitute financial drip feed, keeping alive an institution that has been suffering losses for a long time due to competition from courier companies and parcel delivery lockers.
Firms will pay for postage only if a public entity, authority or court is not involved, i.e. when sending a letter to another company or an individual.
Okay, so we already know what companies should do with regard to the implementation of e-delivery. But what if they fail to do this? Would they face any fines?
No, the e-Delivery Act does not provide for any penalties for a company's failure to set up an e-delivery account. The probable assumption is that for the time being, the benefits of having such an account will be sufficient motivation for companies to implement e-delivery. The absence of an e-delivery address may in the future make it more difficult for a business to operate and meet its information obligations.
Thank you for watching this episode. See you next time.